Today we're tackling something huge, intellectual property. It's this concept of owning, well, an idea, and it's absolutely everywhere, woven into our world even when we don't see it.
So, let me ask you a question. What could a novel, a brand new vaccine, and a famous company logo possibly have in common? I mean, on the surface, they seem like they're from completely different universes, right? But believe it or not, they share a really fundamental connection.
And there it is. They're all property of the mind. Every single one of them started out as just an idea, a spark in someone's brain. They are creations born from human intellect, from creativity and innovation.
Okay, so if we're calling these things property, what does that actually mean? And what makes an idea valuable enough that we need to create laws to protect it? Well, let's dive in and break it all down.
So here's the official definition for you. Intellectual property, or just IP for short, is the legal name for all these creations that you can't, physically touch. And it's a huge category, covering everything from the design of the smartphone in your hand to a secret recipe for a soda.
And when you have this kind of property, you also get a special set of rights. We call them intellectual property rights, or IPR. Think of them like a legal toolkit that gives a creator control over their work. But here's the most important part. It's only for a certain period of time. That limit is a crucial piece of the puzzle.
Now, this whole world of IP isn't just one giant, messy bucket. It's actually pretty well organized. The law splits it into two main categories to handle all the different kinds of things people create.
On one side, you've got what's called industrial property. This is the stuff of business and innovation, patents for new inventions, trademarks for brand logos, and unique designs for products. Then, on the other side, you have copyright. This covers the world of arts and culture, the books we read, the music we listen to, the movies we watch. You get the idea.
And what's really amazing is just how broad copyright is. You might think it's just for, classic paintings or famous novels, but nope, it covers a massive range of things, from the script for a movie and its soundtrack all the way to the architectural blueprints for a new skyscraper.
Now, this is a point you have to get. It's so important. You can't copyright a general idea. So the idea of a boy wizard who goes to a magic school, not copyrightable. But the unique story you write, your specific characters, the exact words you choose to tell that story, that is protected. And the best part? The protection is automatic. The second you create it, the right is yours.
Okay, but what happens when an idea travels? We live in a globalized world after all. A song written in one country can literally become a viral hit across the entire planet overnight. So how in the world do you protect it everywhere?
As businesses and culture started to cross borders more and more, it became obvious that a patchwork of different laws in every country just wasn't going to cut it. It would be chaos. So creators and inventors needed a unified system, which led to the creation of international agreements.
And the biggest, most important one of these is the TRIPS agreement. It's managed by the World Trade Organization, and it went into effect back in 1995. The whole goal was to get every country on the same page, to create a baseline set of rules for protecting IP so that global trade could be more predictable and secure for everyone.
So that's the big international agreement. But how does a treaty like that actually change the laws for people on the ground? Well, let's take a look at India as a case study to see exactly how these global rules become local laws.
When India signed the TRIPS agreement, it was making a really big promise. It was committing to updating all of its own intellectual property laws to match these new global standards. And this wasn't just a few minor tweaks. We're talking about a major overhaul of its entire legal system.
This timeline really lays out the whole journey. You can see the early laws starting in 1911, and then a big update in 1970 for post-independence India. But the real pivot point is 1995 with TRIPS. That 2005 amendment was a direct result of that agreement, and it totally changed the game by expanding what could be patented, especially in critical fields like pharmaceuticals.
And one of the most concrete results of aligning with these global standards is the term of protection. Under India's current Patents Act, an inventor gets exclusive rights over their invention for a period of 20 years.
So we've covered what IP is, how it's sorted, and how it's governed around the world. But that really brings us to the biggest question of all. Why do we even have this complex system in the first place? Why does any of this matter? At the end of the day, the core idea is pretty simple. It's a bargain. By giving creators a temporary monopoly over their work, we give them an incentive to keep creating. It lets artists make a living and inventors profit from their hard work. And in return for that protection, they have to share their creations with the public, which helps all of society move forward.
If you've ever created, well, anything, a video, a song, a photo, even just a blog post, then you've already walked right into the world of copyright, probably without even realizing it. And honestly, it's one of the most important ideas to get your head around if you're making or sharing stuff today. All right, let's get into it and figure out what this all really means. So let's start with a classic question. You're making a video and you find the absolute perfect song for it online. It's just there. So, can you just use it? It seems like it should be a simple yes or no, right? But, well, the answer is a little more complicated than that. And that's where something called copyright comes in. The best way to think about it isn't as a barrier or a rule book full of no's. Instead, picture it as this powerful, invisible legal shield that's there specifically to protect the people who make the things we all love. So here's our game plan. We're going to start with this idea of the invisible shield. Then we'll look at what it actually protects. We'll figure out how long that protection lasts with the 60-year clock. Then we'll get into the two main powers it gives every creator. And finally, we'll wrap up with why all this stuff matters so much. Okay, first up, let's really get to grips with the foundation of copyright, what I'm calling the creator's invisible shield. And to be really specific, we're going to focus on the rules in India, where everything is laid out in one key law, the Copyright Act of 1957. You can think of this as the official rulebook for all creative work in the country. Now, this right here is probably the single most important principle of copyright you need to understand. It does not protect an idea. So you can't copyright the idea of a romance story about star-crossed lovers, but you absolutely can copyright your specific novel with your unique characters and dialogue. It's the tangible expression that gets the shield, not the thought itself. So if copyright protects the expression of an idea, the next obvious question is, what kinds of expressions or works are we actually talking about here? And the Copyright Act is actually pretty broad. It covers all the things you'd probably expect, right? Literary works like books, dramatic and musical stuff, paintings, movies. But it also covers things like sound recordings, the specific audio of a song, and even individual photographs. Basically, if you made it and it's original, it's almost certainly on this list. Okay, this brings us to a huge, and I mean huge, misconception. Do you have to fill out some government form or pay a fee to get this copyright shield? And the answer is a big, clear no. Protection is totally automatic. The very second you finish writing that poem, or click save on that photograph, or record that melody, the moment your work is fixed in some kind of tangible form, bam, the copyright exists. You don't have to do another thing. So why does a copyright registration office even exist then? Good question. Well, even though you don't need to register, it can be super helpful. If you ever have to go to court because someone stole your work, having that official registration certificate is powerful upfront proof that you're the owner. It's really just like having an official time-stamped receipt for your creation. Right, so this protection is automatic, but it isn't forever. There's a ticking clock. So just how long does this invisible shield last? The magic number in India is 60 years. But hang on, it's not quite as simple as just adding 60 years from the day you created something. The really important question is, when does that 60-year clock actually start ticking? And it depends on the type of work. For things like books, songs, or paintings, the clock doesn't start until the year after the creator's death. So it covers their entire lifetime, plus another 60 years for their heirs. But for other works, like films, photos, or sound recordings, that 60-year clock starts ticking from the date it was first published. So you have this protection for 60-plus years. What does that actually give you? Well, copyright essentially hands a creator two different sets of powers: the power to control your work's financial life and the power to protect its artistic soul. We call these economic and moral rights. To put it really simply, economic rights are all about the money. They make sure you can get a financial reward for what you've made. Moral rights, though, they're about your personal connection to your creation, about protecting your legacy and the work's integrity. Let's break down those economic rights. You can think of them as 5 key ways you control how your work makes money. You, and only you, have the right to make copies, to sell or rent those copies, to broadcast it, to create new versions or adaptations, and to translate it. It's total control over the commercial side of things. Okay, so the business side is locked down. But that's not the whole story, is it? What about protecting the art itself? the creator's original vision, the actual heart and soul of the thing you poured yourself into? The power of moral rights was put on full display in a really famous case. A sculptor named Amarnath Sehgal made this incredible, huge mural for a government building in India. Years later, without asking him, they just tore it down and threw the pieces in a storeroom. He sued, and the court sided with him, saying that even if someone buys your art, they can't take away your moral right to protect it from being destroyed or disrespected. So these moral rights really break down into three main categories. First is the right of paternity. That's just your right to be named as the author, to get the credit. Then there's the right of integrity, which is what we saw in that court case, the right to stop someone from distorting or damaging your work. And finally, there's even a right of retraction, which allows an author to pull their work from the public eye. Okay, let's zoom out. We've gone through all the nuts and bolts, but on a bigger scale, why does any of this matter? Why do we as a society even have this system in the first place? When you boil it all down, copyright serves a few massive purposes. It makes sure that artists and inventors can actually get paid for their work. And that financial incentive, it encourages more people to create new and innovative things for all of us to enjoy. It gives creators control, and, of course, it gives them a legal weapon to fight back against pure plagiarism. A patent. Simply put, a patent is an official government-backed document. It gives an inventor total and exclusive ownership of their invention. It's a super powerful legal right that basically says to the whole world, hey, this idea, it's mine, and I control how it's used. So, how long does this protection last? Well, in India, a patent gives you 20 years of exclusive control, and that clock starts ticking the day you file the application. That's 2 full decades to develop and market your idea without any competition. Of course, there's a whole rule book for this. The entire patent system here in India is all laid out in a specific law, the Patents Act of 1970. It's been updated over the years, to keep up with the times and new technology. So what do we really mean by exclusive rights? It means the person holding the patent, and only them, has the legal right to make, use, sell, or import their invention. It's about having complete control for that 20-year stretch. Okay, so you've got a great invention and you want that 20-year protection. How do you get it? Well, your idea has to pass 3 really important tests before it can even be considered patentable. Let's break these down. First up is novelty. Your invention has to be genuinely new. Something about it has to be different from anything that's come before. Second, non-obviousness. This means it has to be a real inventive leap, not just a simple common sense tweak to something that already exists. And finally, industrial application. Your invention needs to have a practical use. It has to be something you can actually make or use in some industry. A purely theoretical idea just won't cut it. So we've gone through the what and the how, but now let's pull back and look at the bigger picture. Why does all of this matter so much? Really, the whole purpose of the patent system is to drive progress. By protecting ideas, it encourages scientists and engineers to do new research. It rewards inventors for all their hard work. It lets them actually benefit financially, which in turn boosts the economy. It creates this whole cycle of innovation that, as we saw earlier, can literally change people's lives for the better. And that brings us full circle. Ultimately, the patent system is what lets a brilliant idea, like the breathing sensor apparatus, become a protected innovation. It gives creators the security they need to really develop their ideas and share them with the world, knowing their contribution is legally theirs.
All right, take a look at these. The McDonald's Golden Arches, the Nike swoosh, the Apple logo. I mean, they're some of the most famous symbols on the entire planet. You see them, and you instantly know the company, the product, and probably even how it makes you feel. They're way more than just cool designs. They are seriously powerful assets. And they all share a very specific and very strong form of legal protection. And that protection? It starts with the most visible part of our brand fortress, the mark. Think of this as your company's flag, flying high for everyone out there to see. It's the first thing your customers are going to recognize, and it's absolutely your first line of defense in a super crowded marketplace.
So what even is a trademark, officially? Well, it's any kind of brand entity, a word, a design, a color combo that makes your stuff stand out from everyone else's. Think about the unique shape of a Coca-Cola bottle. You know exactly what it is, even if there's no label on it. It's a powerful identifier that basically tells the world, hey, this is ours.
But a trademark does so much more than just act like a name tag. It's really a multi-tool for your brand. For starters, it tells you where the product came from. It also acts as a guarantee of quality. You expect a certain standard from a brand you know and trust. It's also like a constant, silent advertisement. And finally, it builds an entire image, a personality, for the brand right inside your mind.
Okay, now we need to clear something up that trips a lot of people up. It's a really critical distinction for any business owner. We need to look at the blueprint here and figure out the difference between the name you register with the government and the brand you actually show to the world.
So here's the breakdown. A trade name is the official legal name of the business. You can think of it like what's on the company's birth certificate. A trademark, on the other hand, that's the marketing identity, the symbol, the name, the logo you use to actually sell stuff. A single company can have just one trade name, but it can have tons of different trademarks for all its different products.
And this is the most important part, the crucial difference. Just registering your trade name, your doing business as name, does not automatically protect your brand. For that level of protection, to actually stop other people from using a similar name or logo, you need a registered trademark. That is the real shield.
Okay, so we've secured the castle walls with trademarks. These are all public-facing, they're meant to be seen, but you know every fortress has treasure locked away in a vault. What about the confidential ideas, the secret recipes, the strategies that give you that competitive edge? What about all the things you absolutely don't want anyone to see?
And this brings us deep inside the fortress, to the room with the crown jewels. We are now entering the world of trade secrets. These are the hidden, confidential assets that can be even more valuable than a public brand, precisely because their power comes from the fact that they are secret.
You know, a trade secret can be almost anything, as long as it's kept confidential and it gives you an advantage. I mean, we're talking about legendary stuff here, like the secret formula for Coca-Cola or Google's search algorithm. It's basically any piece of information that helps you win because your competitors don't have it. But what happens if someone tries to steal those secrets? Unlike trademarks, there isn't always a simple registration you can file. So how does the law actually protect them? To really get this, we've got to look at a landmark case that helped define what a trade secret truly is in the eyes of the court.
The case is Burlington Home Shopping versus Rajneesh Chibber, which was heard by the Delhi High Court in India way back in 1995. This case ended up being incredibly important because it forced the court to lay out a really clear, modern definition for what actually qualifies as a protectable trade secret. And the court's decision gave us this clear three-part test. For something to be a trade secret, 1, it has to have commercial value. 2, it can't be public knowledge. And 3, if it got out, its disclosure would have to cause real, significant harm to the owner. This definition created a really powerful framework for protecting a company's confidential information.
So how is this all enforced? Well, interestingly enough, many countries, including India, don't have a single trade secret act. Instead, the protection is more of a patchwork. It's pieced together from contract law, from common law principles about confidentiality, and, this is a big one, from restrictive clauses that businesses write directly into their employee contracts. You essentially have to build your own legal safeguards.
So, we've built our fortress, we've got visible trademarks on the outside and hidden trade secrets locked away on the inside. But let's take a step back and look at the bigger picture. Why is all this so important, not just for one company, but for the entire economy?
When you boil it all down, it's really about trust and innovation. Trademarks protect a company's goodwill, that reputation they've maybe spent years building. And trade secret laws encourage companies to invest in research and development, knowing that their big breakthroughs can actually be protected. Together, these tools make sure a brand's unique identity is secure, and that fosters creativity and fair competition for everyone.
A geographical indication, or GI. And the whole idea here is this really strong link between a place and a product. A GI is basically a legal sign that says this product comes from this specific place, and because it comes from there, it has a certain quality, a special reputation. The origin is what makes it special.
And these examples just make it so clear, right? Darjeeling tea can only truly be Darjeeling tea if it's from West Bengal. Why? Because the soil, the climate, the altitude, it all creates that one-of-a-kind flavor. It's the same deal with the traditional Warli painting or that rich Malabar Robusta coffee. The place isn't just a location, the place is the brand.
Okay, so we've got a handle on protecting where something comes from. Now let's switch gears completely. We're moving from place to appearance to explore how you protect what something looks like. This is a whole different side of creativity, focused entirely on the aesthetics, the visual appeal.
And this is called a design right. It's all about protecting the unique look and feel of an item. We're not talking about how it works or what its purpose is. This is purely about the visual stuff, the ornamental features that make you go, oh, I recognize that. So this is the really crucial distinction to get. A design right covers the shape, the cool patterns, the color scheme, all the things that appeal to your eye. What it absolutely does not cover are the functional bits. So you can't get a design right on the basic mechanics of an engine, but you can for sure protect the unique, stylish body of the car it's in. It's all about form, not function. And hey, would you look at that? We're right back to our original puzzle. That distinctive wrapper on your favorite chocolate bar? That's a protected design. The sleek body of that new car, a protected design. And that iconic curved shape of a soda bottle that you'd recognize even in the dark, you guessed it, a textbook example of a protected design. So we have GIs for place and design rights for looks. But this all kind of brings up a bigger question, doesn't it? Why do we even have these rules in the first place? Why does society go to all this trouble to protect ideas? Well, the logic behind it is actually pretty simple and really powerful. First off, it's about reward. I mean, if you pour your time, money, and soul into creating something, it just feels fair that you get to benefit from it, right? Second, it's about encouragement. Giving creators these rights offers a real economic reason to keep inventing and creating new things. And third, it's about promotion. When you protect creative rights, you build a system of fair competition that actually helps the whole economy grow. Now, it's important to remember, these ideas aren't just local anymore. In the world we live in today, so interconnected, protecting creativity has become this huge, complex, global challenge. And this quote really just hits the nail on the head. In an age where you can send an idea around the world in a split second, you just can't think about protecting it within your own country's borders. It's an international game now, and it needs international rules. And that leaves us with this one last, really big question to think about. We absolutely want to reward creators for their hard work. But we also want new ideas and new knowledge to spread so other people can build on them. So what's the perfect balance? How do we protect the rights of an individual creator without accidentally putting the brakes on progress for everyone else? That, right there, is the central challenge for intellectual property today.